Today we are going to discuss some new topic about the Indian Transfer of the Property Act. So, in the concept of the Transfer of the Property Act, we have discussed, yeah, on the concept of the TP Act 1882, we have discussed the other concept like the concept of the how the lease has been done, how the gift is being given, what is the concept of the exchange. So these things we have already discussed, and we have also discussed that what is a mortgage, who is a mortgager, who is a mortgagee, how the mortgage is being done, that also we have discussed. So today we are going to discuss the chapter 3 of the TP Act, that is the very important concept you can say, and it defines about the concept of the sale. You know what do you mean by sale? Sale means something when you are giving or you are just selling the thing in exchange of a specific amount of the money or any kind of the consideration, that is called the sale. Okay, so sale, the definition, the official definition of the sale, that is being explained under section 54 of the TP Act. Let me just read it out. So when we're talking about the concept of the sale, exactly signifies sale is a transfer of ownership in exchange for a price paid or promised, or partly paid or partly promised. So what is sale? Sale is the transfer of the ownership of a property or a specific thing in exchange of the price paid or promised, or partly paid or partly promised. So what do we mean by this? Let's understand what do we mean by sale. अगर कोई हमें बोलता है ना कि we the property is being sold or there is the sale of the specific property, तो what is the exact meaning of the sale? Okay, sale means the transfer of the ownership of the property. Okay, for example, I am transferring my specific goods to you. Okay, or you are transferring your specific goods to me. If that is being transferred for a specific time period, or that specific thing is being transferred, the possession of the property is being transferred but the ownership is not being transferred, then it will come under the concept of the bail or lease or something like that. If the property is being the immovable property, it will come under the concept of the lease, and if it is the movable property, it will come under the concept of the bail, right? So those are the different kinds of the transfer. And we have also discussed the transfer of the property without consideration, that is called the gift, in which we have discussed that the gift must be transferred without any consideration taking ahead. But here, when we are talking about the sale, sale is the transfer of the property where the consideration is the primary factor over here. Without the consideration, a sale is always been incomplete. The sale is considered as been completed when there is the specific payment has been done, specific consideration has been given. Then only we can say that yes, the sale is being completed after all, right? So sale is the transfer of the ownership of the property. प्रॉपर्टी का जो ओनरशिप है ना, वो ओनरशिप ट्रांसफर करने को सेल बोलते हैं. इन रिटर्न और इन एक्सचेंज ऑफ ए प्राइस पेड, उसी के बदले हम कोई स्पेसिफिक अमाउंट का पैसा दे रहे हैं, राइट? और प्रॉमिस्ड, और आई हैव बीन प्रॉमिस्ड, मैं यहाँ पे एक प्रॉमिस कर रही हूँ कि हाँ ठीक है, मैं इतना पैसा दे दूंगी करके इन रिटर्न ऑफ दैट स्पेसिफिक गुड. और पार्टली पेड और पार्टली प्रॉमिस्ड. For example, the specific price of the good is up to the amount of 30,000 of the rupees, and I am paying up to the amount of 15,000 rupees at a right moment, and I am promising, partly promising that हाँ बाकी 15,000 रुपया मैं बाद में दे दूंगी. Either partly paid और पार्टली प्रोमिस्ड, मैं यहाँ पे पार्ट प्रोमिस कर रही हूँ कि हाँ ये जो अमाउंट का जो 15,000 रुपया है दैट आई एम गोइंग टू पे लेटर. So there must be a specific thing that should be present in the case of the sale, that is called the consideration. The consideration must need to be there. So sale is the transfer of the ownership of the property in exchange of a price paid or promised, or partly paid or partly promised. So when we are talking about the sale of a specific goods, then we need to consider that the sale is the transfer of the property when it is fully given in exchange of the consideration. Without consideration, the sale is not been completed. If any kind of the property or any kind of the immovable or movable thing is being given or is being transferred without any consideration, that is called the gratuitous transfer, and the gratuitous transfer leads to the concept of the gift. Gift is a concept where there is no consideration is being present. Gift has to be given without any consideration. When there is the concept of the gift, the person who is gifting the property, he cannot take a single penny from the person to whom he is gifting something. But in sale, yes, you can take the consideration, and you have to take the consideration, because without consideration the sale is not been completed. Okay. So moreover, when we are defining sale, that means it is the transfer of the ownership in exchange of a price paid or promised, or partly paid or partly promised. What does it mean? It means sale is the specific down of the ownership, specific transfer of the ownership in exchange for a price, specific price only, price paid or promised, or partly paid or partly promised. And one more important thing, when we have discussed about the concept of the exchange, I have told you the exchange can be done with any kind of the consideration. The consideration that is being given in the exchange, that is not mandatory that it should be always money only. It can be anything rather than the money, right? But here, when we are talking about the concept of the the sale means the transfer of the ownership in exchange for a price paid or promised, or partly paid or partly promised. The sale is always based on the money only. जहां पे हम कोई सामान बेचते हैं ना, उसी के बदले हम पैसे ही लेते हैं, चावल नहीं लेते हैं. अगर चावल के बदले दाल खरीदा जाता है, दाल के बदले चावल खरीदा जाता है, then that is called the concept of the exchange, that is not called sale. सेल मतलब सामान के बदले पैसा लेने का है, सामान के बदले पैसा देने का है. दैट इज द मोस्ट इंपोर्टेंट थिंग इन द concept of the sale. Okay. Then comes section 54. Under the section 54, the one more concept that is being coming, that how the sale is made. So when we're talking about the sale, you may ask me that we are talking that the sale is being made and all these things, then can we know that how the sale is being made, right? So when there is the sale of a tangible immovable property, then it worth 100 or more, then it requires a registered instrument to do the registration. Okay, got it? So when we are talking about that how sale is being made, sale किसी तरीके से किया जाता है, then in that situation he told me that when there is the sale of the immovable property, tangible immovable property, tangible means the clear, the immovable property which is clearly visible, which is clearly observable in nature, and it is costing more than 100 rupees according to its worth, then it requires a registered instrument. Got it? Then it comes when it is less than 100 rupees. So when we're talking about the less than 100, it can be done by either registered instrument or deliver or the delivery of the possession, right? So when the sale is being done less than 100 rupees, it can be done by either the registered document or delivery of possession, right? And when it is more than amount of worth 100 rupees, then it requires a registered instrument for sure. Okay. Okay. So when we're talking about the any kind of the tangible immovable property which cost more than 100 rupees, in that specific circumstances it requires uh, a registered instrument. So when we're talking about the thing which is less than 100, which is more than 100 rupees, then it requires a registered instrument. The thing or the goods which is more than 100 rupees in nature, जिसका जो amount है worth है ना सामान का, वो 100 rupees से हमेशा से ज़्यादा होता है, right? So in that specific circumstances, uh, it is told that it requires a registered instrument after all, right? So when we're talking about the thing which is less than 100 rupees, then it can be done by either registered instrument or by the delivery of the possession. And the third one, when we're talking about the delivery, is when the seller hands over a possession of the property, then the buyer or someone authorized on behalf of the buyer can receive the property to the seller. Okay. Then in that specific circumstances, let us understand it. The first point we have discussed, that the definition of a sale, that under that I have made you understand that it is a transfer of the property or transfer of the ownership of the property in a permanent basis. When we are talking about the mortgage or lease, in that specific circumstances, the thing has been transferred for a smaller period of the time. The duration is smaller in nature. But when we are talking about the sale, it has been done for a permanent basis, for a long term basis, right? So sorry, okay. So when we're talking about the sale, it is the permanent transfer of the property. It is not temporary in nature. When I am selling something to someone, then I am transferring the ownership in a fully manner. I am not keeping the property, any of the property with me. I am totally giving the property to that person, right? So when the property is a tangible, immovable property, then it requires a registered instrument. It requires a registered agreement. This is the first thing. Okay. Then comes the second point. The second point is it is pricely paid, promised, then partly paid or partly promised. Okay, got it? So when we're talking about section 54, and we have discussed that how the sale is being made. Under that we discussed if the property is tangible and immovable in nature, it will worth more than 100 crore, and it requires a registered instrument at all. In the second condition, when it is less than 100, it can be done by either registered instrument or by the delivery of the possession. Okay. So when it is less than 100, it can be done by the either of the instrument or the delivery of the possession. That means when the thing is less than 100 rupees, it is not always necessary to take it back, right? So it can be done by either of the registered instrument also. Either of the registered instrument can do any kind of the registered instrument that is less than rupees 100, and any kind of the tangible movable property which is worth 100 or more, it requires a registered instrument for sure, right? And then thirdly comes the delivery. When the seller hands down or when the seller hands over the possession of the property and to the buyer or someone authorized of the buyer, right? So for example, there is a person who is the seller. He hands over the possession of the property to the buyer, okay, or someone authorized to the buyer. Then also the sale is being completed, right? That means, for example, I am the seller over here. You are coming on behalf of your owner to take the property, right? So when we are talking about the when we are talking about this, then we must know that the seller hands over possession to the property to the buyer or someone authorized by the buyer. Either the buyer has to take the possession of the property in a full on manner. After the full payment, when the proper agreement is being completed, it will be considered that the sale is being completed, right? When the seller hands over possession of the property to the buyer or someone authorized by the buyer. For example, there is a person who is authorized by the buyer to sell the specific property, right? So the person is called as the representative of the buyer. Even if the buyer is himself not present, till the property can be transferred to the person who is the buyer or to someone who is authorized by the buyer. So when we're talking about that how the sale is being made, we have discussed three conditions over here. The primary condition is when the value of the property is below 100 rupees, then it doesn't require any kind of the mandatory registration instrument, registered instrument. There is no need to do mandatorily that yes, this thing need to be done with the registered instrument only. There should be the proper procedure to do the sale and all. That is not important, right? But when the thing is more than worth of the rest 100 rupees, it mandatorily requires a registered instrument at all. This is the primary thing we have discussed. And the third one we have discussed that when the seller hands over the possession of the property to the buyer or to someone authorized who is on behalf of the buyer, then this will be considered as the this will be considered according to the concept of the delivery only, right? Then comes section 154, the second clause. It speaks about the contract for the sale, right? So when we're talking about the contract of the sale, under that we have to understand that the sale, an agreement that is a sale will always be occur according to the agreed terms and conditions, right? So when we're talking about when there is the sale, it must need to be done with the proper agreed terms and conditions. Okay, so we have discussed under section 54 that yes, the agreement of the sale that must need to be done with the all the agreed terms and conditions. The first thing. Then the second thing is when we're talking about the it doesn't create ownership rights or interest in the property only until and unless the sale is completed. Until and unless the ownership is been fully transferred to the buyer, it does not create the ownership right interest in the property, right? Got it? So when we are talking about the contract of the sale, then we need to understand that an agreement, that is a sale, will always be occurred with the agreed terms and the conditions. There must be the presence of the agreed terms and conditions when there is a contract of the sale. This is the primary thing. Then comes the secondary thing. It does not create ownership rights to invest in the property on until the sale is completed, right? So when, until and unless the sale is completed, it does not create the ownership rights or interest in the property. The ownership rights is important, and we need to understand that the property, until it is the sale of the property, then it must needed to be uh, then it must needed to be bound by the certain liabilities, right? So when we're talking about the contract of the sale, an agreement that a sale will occur on agreed terms and conditions, certain rules and regulations, that is called the contract of the sale. Got it? Then we are understanding about the does not care ownership right or interest. It means when we are talking about the ownership, the transferring of the ownership rights or the interest, it is not completed unless and until the sale is complete. That means the ownership right and interest will be completed when the sale is being completed. Got it? Then comes section 55. It speaks about certain rights and the liabilities of the buyer and the seller, right? So when we're talking about the seller's duties, the buyers of the seller, right? So what will happen in that situation? In that situation where we're talking about the duty of the seller, the first duty is to disclose the facts that is been informed to the buyer about material facts in the property or title that the buyer cannot discover with the reasonable care, right? That means if there is a person who is the seller and there is a person who is a buyer, in that specific circumstances, the person who is a seller, while delivering his goods, is responsible to inform the material defects that is been associated with the property, right? So when we're talking about the disclosure of the facts, it is clearly understandable that it informs the broad it then it is clear that he or she must need to inform the person who is buying the specific goods. So when we're talking about the disclosure facts, it informs the buyer defe- about the marital defects in the property or title that the buyer cannot discover with the reasonable care. So if there is a situation that even if the buyer will take a reasonable care of the property, will try to understand what is the problem actually, still the person who is the buyer, he will not be able to find it out that what is the defect in the property. So here in this situation, it is up to the seller, right? That the seller wants it or not. Okay. So we discussed about the first point. The second point we are talking about the provide title documents. So what are the all the title documents that is available for the buyer's inspection, right? So when we're talking about the seller's duty, it is indicated that the disclose defects, that means the to inform the buyer and about the marital defects in the property or title that the buyer cannot discover with the reasonable care. It is clearly seen that even if the buyer will take the reasonable care to observe the property, still he or she is unable, will not be able to find out what is the actual fault in the property. So here it is the duty of the seller to inform the buyer about the material facts in the property itself, right? Then comes section 55. It speaks about the duties. Then comes the second point. It speaks about the title. It speaks about the title on the document, right? So when we're talking about the providing title documents, so all the types of the title documents that is available for the boy's perception, right? Okay. The next point we have talked about that answering the questions. The first point is about the title and the title transfer, right? So when we're talking about the duty of the seller to disclose the facts, similarly, it is the duty of the seller to provide the title document. That means to make all the title documents available for the buyer's perspection, right? So when we're talking about the rights and liability of the buyer and the seller, right? The first point we discussed about the disclosure of the fact. The second point we discussed about the providing of the title documents. And the third thing we'll discuss about the answering of the question. Then fourth thing will come about the executing the sale deed. Fifth one, fifth one, take care of the property. Sixth one, hand over possession. Seventh one, it is about the pay taxes, rent, and um clear encumbrances until the date of the sale. Right? So when you're talking about the third point, that was about the answering questions, right? So when there is a seller and there is a buyer, the seller must respond to the buyer's questions about the property and title in a truthful manner. So whatever is the nature of the goods, the answers must be responded to the buyer in a very proper and honest manner by the seller, right? And the fourth point is about the executing the sale deed, right? The deliver of the property executed in the deed upon the payment. There must be a sale deed is being done while delivering the document and after the payment of the property. Payment on the property. Then comes the fifth point. It speaks about the taking care of the property. What does it mean? It means it maintain the property and title documents until it is being delivered. And the sixth point, it we are speaking about the handover of the possession while providing possession to the buys, buyer after the sale is completed. And the last clarity, it must have the clear liability, just like the paying of the taxes, the rents, and clear encumbrances until the date of the sale. The day on which the sale is being done, till the date of the sale, the things must be clearly given. For example, the liability like the taxes, the rent, it must be cleared out, right? So these are the primary duties of the seller. The first thing we discussed, defect. If there is any kind of the defect in the property, the defect must be disclosed. The first thing. The second thing, providing the title of the documents. All the title documents that is needed to the buyer after the sale, that must be delivered to the by the seller to the buyer. The third duty, to answer the questions of the buyer about the property and the title. Whatever the nature of the property, the title of the property, if the buyer is asking any kind of the question to the seller, it is the duty of the seller to clarify the questions to the buyer. This is the third point. The fourth point, we are talking about the executing of the sale deed, where we understood that if the property is below 100 rupees, then in that specific circumstances there is no specific requirement of a registered instrument, while the property is above 100 rupees, then there is the mandatorily need of a registered document that must need to be done. Then the fifth point is the taking care of the property, where we need to understand that if the property is belonging to the seller and the property is being transferring to the buyer, then it is the duty of the seller to take the proper care of the property and the title documents, whatever the documents of the property, whatever the papers of the property, the transferring documents, that must need to be taken care in a proper manner, and the proper need to be maintained. If I am selling a house of mine, for example, the full possession of the house will be transferred after 2 years or the 2 months. So till the duration of the 2 month, as a seller, it is not my it isn't it my responsibility to take care of my own property? Yes. Even if the property is going to be sold, I have to take care of the property in a proper manner until and unless the sale is been completed or the title documents has been delivered completely. The next point is about the handovering the possession of the property. The possession must be delivered to the buyer after the sale is completed. Then comes clear liabilities. For example, there are always there has been the pending taxes, rents on the specific property. So when there is a person who is a seller, another person is the buyer, and the person who is the seller, he is transferring the liabilities of the property to the buyer itself, then he must clear the liabilities till the date of the transfer of the property. For example, I am transferring a land of mine, or I am selling a land of mine on which there is a debt amount up to the amount up to 2 lakh of the rupees, right? So in every month I have to pay or repay the amount for my loan, that the debt I have taken up to the 2 lakh of the rupees. In every month I have to pay 13,000 or 14,000 rupees to a specific bank as the repayment of the loan, right? This is primarily fixed. You know the EMI, right? For example, I have bought a car, I have to pay the EMI up to 15,000 per month, right? I am selling my car to you. You are enjoying the benefit that is arisen from the car. The car has not been used for a longer time, and I have just used the car for the duration of 1 year. And there is more 1 year is wait left to complete the EMI of the car. So if I am selling you the car, you are being the owner of the property, you are being the owner of the car, and the car is being transferred to your name. So you have the responsibility to pay the EMI also. In the similar way, if I am repaying for the specific loan amount of the land of mine and I have sold you the land, if you are gaining the amount of 25,000 rupees from the land, you have to pay the 15,000 rupees per month that is being usually given, because you are the sole owner of the land now, and as a process, when you are receiving certain amount of the benefits from the land, you have to pay the dues that is being left with the land also. But until and unless the transfer is been completed, until and unless the ownership is been transferred, till that date I have to pay the specific amount. Till then I have to do the payment, and I have to take the responsibilities, take the liabilities until the date of the sale. Okay. For example, the sale is being done in the month of the February. Till the month of the February, I have to clear all my dues. I have to clear all my liabilities. This is under section 55, which is talking about the duty of the seller. Then we are talking about the duty of the buyer. What are the duty of the buyer? The primary duty is about the disclosing of the facts, right? For example, I am taking any land of yours and you are selling your land to me, and you are staying at a location when you are just not aware about the current scenario of the society, right? Your land which is you are selling up to the worth of 2 lakh of the rupees, that is actually causing the worth of the 10 lakh of the rupees, and you are unaware about this. You don't know that your property is so valuable. For example, you are an illiterate person who doesn't have any knowledge, right? So what you are doing, you are selling the land which is up to 10 crore of the rupees with the amount up to the 2 crore of the rupees. So here, as a buyer, if I am buying the property from you, it is my responsibility to make you concerned, to make you awake that you are doing a wrong thing here. The property you are transferring, that is not actually cost 2 crore of the rupees. The actual cost of the property is 10 crore of the rupees, so you have to sell the property in a proper amount. If even after I have the idea that yes, this property is not up to the 2 crore but up to the 10 crore, but still I am buying the property from you with the amount up to 2 crore, that will be considered as a fraud. So disclosure of the fact means it is the duty of the buyer to inform the seller about any known facts that might affect the value of the property but are unknown to the seller. The seller is unaware about that, but the seller should know. Seller should get the information about the specific property. Then it is the duty of the buyer to inform the seller about the specific value of the property and the specific fact they are ahead. The second point, to pay the price, right? The payment must need to be done at the time and place of the sale completion, right? When the sale is being completed, the particular price need to be paid. The third point, bear losses. After the ownership passes, bear losses and damages of the property. If I have become the owner of the property, if the ownership of the property has been transferred to me, then after the transfer, as the owner of the property, whatever losses or damages will occur to me, who will be the sole owner to enjoy this? Who will be the sole responsible man to take care of that? Obviously, me. Because as the owner of the property, the benefits will be all mine and the losses will be all mine also. I cannot neglect the losses for the sake of the benefits. I cannot say that no, I will take the benefits only and I'll just reject the losses. No, the property is mine right now. I have bought that property. I am the owner of the property after the sale process completion. So I cannot escape from the losses. I have to take the losses and the damages along with the benefits also. And the last and most important thing, to pay the dues. After the ownership passes, any public charges or other dues like encumbrances must be paid off. Any kind of the public charges or any kind of the loans or debt amount that is left with the property. So when I am becoming the new owner of the property, I have to pay the new debts that is being arised. Or for example, as I was telling you, there is a car I have bought from you and 1 year EMI is still left. So I have to pay the EMI up to 15,000 of the rupees in month for the specific car, because the car is recently bought and the EMI is not completed. You have completed the EMI till the date of the transfer. After the date of the transfer or after the date of the sale, I have to take care of the EMIs and the payments, because I have become the owner of the car and I have to take care about the specific expenses of the car. So this is about the buyer's duties under section 55. The next section or the next points we are going to discuss about the seller's liabilities, seller's rights and the buyer's rights. This is what we are going to discuss in the next class. This is all for today. We can close the class here, guys. Thank you. Bye bye. Take care.